The Workplace Relations Amendment, Work Choices, Act 2005, commonly known as Work Choices, significantly amended the Workplace Relations Act 1996. Work Choices removed wage rates from federal awards and notional agreements, preserving state awards, NAPSAs. On March 27, 2007, for employees covered by the Work Choices system, notional Australian pay and classification scales, pay scales, were established. Whilst every federal award and NAPSA has its own notional pay scale existing at law, actual documents encapsulating the scales were never created or published. On December 18, 2007, the AFPC announced that it will suspend the creation and publication of pay scales. Instead, pay scale summaries were eventually published by the Workplace Authority, and are now available from the Fair Work Australia website. They include a disclaimer as follows: the Commonwealth of Australia does not give any guarantee, undertaking or warranty whatsoever in relation to the summary, including in relation to the accuracy, completeness, or currency of the summary. However, they also state that satisfaction of the terms of the summaries will satisfy the Workplace Ombudsman that the employer has complied with its obligations under the pay scale. Pay scales contain coverage provisions, classifications, frequency of payment provisions, and wage rates, including casual loadings, junior, trainee and apprentice rates. Wage rates may be as basic periodic rates of pay, an hourly rate, or, where an award or NAPSA contains such provisions, as basic piece rates of pay. Changes from the previous system of wages contained in awards include that basic periodic rates are now in an hourly, rounded, form rather than weekly as was generally the case in awards, and that wage rates are now adjusted by the Australian Fair Pay Commission rather than the Australian Industrial Relations Commission. Penalty rates, allowances, and loadings other than casual loadings remain allowable award matters. Therefore, they continue to apply, but only to employees covered by the relevant award. Certain employees in the Work Choices system are pay scale only employees, that is, their minimum terms and conditions at work come only from the Australian Fair Pay and Conditions Standard, the standard, including the relevant pay scale. These employees include those who work for businesses created on or after March 27, 2006, and employees who have previously been covered by a collective agreement, CA, or Australian Workplace Agreement, AWA, that has been terminated on or after March 27, 2006. Where a CA or AWA is lodged after the March 27, 2006, a post-reform agreement, it must not contain provisions that are less than the standard, including the relevant pay scale. Where a post-reform agreement contains a basic periodic or piece rate of pay that is less than the relevant pay scale, the pay scale will override that agreement provision.